But maybe we can start with this first one, which is for people who are funding their EB5 investment in installments. I think a better way to say that is people love to say, oh, I want to partially file. Well, I want to partially fund and file an I-526. Getting that priority date in place is very, very important for people, understandably, given the urgency that there is in the EB5 market. So maybe if you could talk a little bit about this pathway that people have been using, maybe what some of the treatment has been in the more recent adjudications you've been seeing.
Yeah, absolutely. So I think some of these adjudications are being caused by the record number of cases being filed right now. There are many people filing, and this is driven a lot by the EB5 program itself. So, just by way of a background to everyone listening here today, we had the EB5 Reform Act passed in 2022. And in the Reform Act, it actually provides for very good protections for EB5 investors, including a grandfathering provision that was specifically put in by the US Congress. And it says if you fund an investment and file your I-526E petition prior to September 30th, 2026, so a little bit less than 1 year away from now, you get grandfathered under the law, meaning that your $800,000 investment will stay $800,000. You will not be required later to invest more money if the program changes. It also importantly means that the investor and their family members can continue going through the immigration process, all of the steps in the EB5 process, even if our US Congress does not extend the EB5 program in the future. So we know that EB5 is extended through September 30th, 2027. But if you file before September 30th, 2026, 1 year before the expiration of the program, you get this grandfathering protection, and it's really, really important for the investors. And we fully understand that. They want to be protected. They want to know that even if our Congress fails to extend EB5 beyond that time in 2027, they can continue through the process after making such a large investment. And we fully understand that. So leading up to this deadline, I think there are a lot of people interested in EB5. People are wanting to do this because EB5 is self-sponsored. They can take control of their immigration process. And this is especially true in a time right now where there is some uncertainty in other types of processes and other types of green cards, in the H-1B petitions. People are worried that their employers won't want to sponsor them for these types of things. So EB5 is becoming more attractive, and people are rushing to file these cases. So we just want everyone to understand that EB5 is a huge decision, and you need to prepare your case correctly. And we know that leading up to September 30th, 2026, many investors will try to meet that deadline so that they can protect themselves and their family, which is great. But preparing for that time is very important. So working with the regional center and the new commercial enterprise where you're going to invest, and also working with your attorney's office to make sure that your case is strong. And funding the EB5 investment in installments, or partial funding, as some people call it, is one type of strategy that investors use so that they can get their case filed earlier. Perhaps they will fund half of their investment, maybe $400,000 or some amount like that, and then they will remit the final installment of another $400,000 later. So this is theoretically possible. And even though we're seeing maybe some pushback from USCIS on installment method funding, I still think it's entirely possible to do if you're doing it correctly, right? So it's not that we have to be so scared about what USCIS is doing. Sometimes they push back. We just make sure that we're filing things correctly. So actually, the EB5 law, Pete, it is always said that an investor can be in the process of investing. This is not something that USCIS has done by policy or only in their policy manual or only on their website. In the process of investing is actually language in the EB5 statute, and it's been there since 1990. And even when we had the Reform Act passed in 2022, it did not change this language. So we've had in the process of investing since 1990. We also have a standard by USCIS that when you're filing your case, it needs to be approvable when filed, meaning you can't make material changes later to a case that you've already filed to make it approvable. So these two things have to work together when we're filing the EB5 petition. So, what does that really mean when USCIS has been pushing back on this? So, a few things. So, first, again, I think it's entirely possible to fund in installments. And what we know from recent adjudications is that USCIS firmly believes that you have to be committed to investing the remaining funds. Okay, so number one, it's my opinion, it would never be acceptable to file an EB5 petition with no money remitted. I think
Mhm.
that would be easy denial by
Yeah.
USCIS. And
Yeah.
one thing I want to caution people is that I also don't think it would be okay if you only remitted an administrative fee and no part of the capital contribution and then
Sure.
tried to file your case. Definitely some portion of the capital contribution should first be funded to the escrow before any EB5 petition gets filed. Then from there has to be an agreement between the investor and the new commercial enterprise that allows for the installment and commits the investor to send future installments by set dates. This, I think, is key for USCIS for you to be in the process of investing. And this, I actually think, comes from the matter of the Zumi decision, where a very long time ago, the USCIS legacy INS, Immigration Naturalization Service, made some rules about the at risk investment. And in that case, the investor was actually funding over time. That person was
Mm.
obligated to fund over time. And USCIS said you can be in the process of investing, but there has to be a present commitment to invest. So I think having a side letter agreement with the new commercial enterprise and the regional center that you're going to commit the additional funding is really important in order to meet that standard. And then we know from other recent adjudications from USCIS that they want to see the investor in the EB5 petition outline when those future installments will be sent. And they also want the investor to prove what is going to be the lawful source of funds for those future installments. And not only do they want you to tell them what the source of funds will be, they want you to submit the documentation to show the lawful source of funds for those future installments. And this, I think, is really important for investors to understand because in the past, I think USCIS may have approved cases where the investor didn't really outline extensively where the future installments will come from. In a request for evidence later, the investor maybe submits some documentation about that. But what I think USCIS is saying now is that we have to see what the source of funds is going to be for those future installments, which tells me that the investors really need to be prepared, right? Like this is an exercise in how are you going to fund $800,000?
Mhm.
And if I've given CanAm $400,000 today, and 3 months later, the additional $400,000 is going to be due, but I don't know how I'm going to fund that yet, then that's maybe a problem, right? So investors have to be prepared and be planned in advance for what is going to be the full source of the funds and what is going to fund those future installments, especially if there's not that much time in between when you make your original installment and when the full amount of the money is due. So I think those are really key. And I think there's been some talk amongst EB5 practitioners that if the investor misses a deadline for funding those additional installments, that might be problematic for USCIS. We're going to have to see how that plays out. So, again, planning, I think, is key here. And knowing when you're going to remit the remaining funds and what is the source of those and preparing the documents in advance is really key for that to be successful.
Which is really great insight, because I think when we've talked a lot about doing source of funds and the type of preparation that goes into it. And I think this is just another extension of that, of what is being ready to go ahead with going and making this type of investment. It's not enough to just say, I know I've got $800,000 coming. I've got a few different spots. Here's the 400 that we're going to start with. And then the other 400 will be coming from somewhere, this spot, or this spot. Well, it's not enough to know that you are good for it. You have to actually show it, document it. Otherwise, USCIS is not necessarily going to be very lenient in terms of the changing that might go with it. They don't want to see, you missing deadlines that you've provided for them in terms of your funding. They don't want to see additional information being interfiled potentially, or interfiled well after the last installment was made, which could potentially lead to complications for it. I mean, all of these things in terms of, and it's not to say that it's impossible to get approval. I certainly couldn't speak for that, but when going forward, you want to make sure that you're putting forward the best case possible. And I think that these sorts of guidelines are tremendously helpful for people in terms of trying to make sure that they are doing that.
Yeah, and I think you bring up one really good point there, Pete, and for everyone listening today. I think the USCIS is signaling that once you've made that second installment, don't wait for the RFE to come in. Send us the documentation that you funded the remaining investment and send us the path of funds relating to that final installment and whatever supplementary source of funds documents are required. And even though USCIS has never published or even really stated a formal process for what interfiling is, like this is kind of like, a lure of something for EB5 related, it's I think a good practice to mail in those documents. That way you can ensure then that the USCIS doesn't claim later that you had some burden to do that. And that they don't have to send an RFE. I don't think that that's correct. I think if USCIS is going to impose some sort of procedural burden on the investor, or they're going to make a new procedure that investors have to follow, they have to tell the public what that is. So USCIS should also proactively tell people what to do in this scenario, because the reality is the statute allows for us to do this. Investors should be allowed to do this. And if you want us to send in the documents before an RFE or something like that, then tell us what the procedure is that we should follow.
Yeah, exactly. Yeah. Again, predictability. Just let us know what the steps are and we'll take them. But if the lack of predictability is certainly, it's the type of things that keep us up at night. But I think just to shift on to another subject here that has definitely been a big point, and it's been a big spot that we've been hearing more and more from, is the use of loans for part of your EB5 investment. And I think all of these things are kind of born out of the same genesis, in that people are coming, they want to invest, they know that they have funds, but they're still either compiling them, or they have some liquid assets that maybe they have difficulty getting in terms of moving forward. But their preference is to invest sooner rather than later, to start their priority date going, to start themselves going towards their benefits. So all of these different pathways have been ways to help to let people accomplish that while still also moving towards their adjudication goals and their immigration goals. But have now been seeing maybe some, I don't want to say pushback, but to see some reaction from USCIS in some of the ways that they've been getting structured. So let's maybe talk a little bit about what you've been seeing in terms of the treatment by USCIS of loans being used for the completion of an EB5 investment.
Sure. Loans are one of the most common types of source of funds that we see. Not everyone wants to liquidate their real property or their other assets, their brokerage accounts and things like
Yeah.
this that they've been, yeah, working to
Make sure
save,
that
right?
consequences or just, yeah, or just the returns that they're making on those. They'd rather keep those parked where they are.
Exactly. And so loans have been used tale as old as time in EB5, as I like to say. Probably the most common type of source of funds for EB5 investors is to take out a secured loan against real property and then use that for EB5. That is a proven type of source of funds that I am sure some very large percentage of all EB5 investors use, 60% or something like that, right? So over
Mm-hmm.
time, we've had a lot of USCIS guidance about what are the rules surrounding when you want to use a loan as investment. And actually, a little bit ago, I would say maybe 6 or 7 years ago, there was a lot of controversy over loans. Could you only use a loan that was secured by the investor's personal assets? Or could you use an unsecured loan for an EB5 investment? That got settled through litigation quite some time ago. And the rule from the court in a federal court decision said that when you get a loan and then the investor receives the proceeds of the loan, that's a cash investment into the new commercial enterprise. It's specifically allowed, cash is specifically an allowed type of investment, and therefore the loan being used as the source of funds did not need to be secured by the investor's personal assets. So maybe, I get a loan and it's secured by my parents' property or something like that. That would be allowed, right? So the collateral that you were using didn't need to be connected directly to the investor any longer. So that was a good development for investors. And it allowed, a wide range of lending scenarios to be